help people with chronic disabilities that can last their whole lifetime. And even though you don't practice personal injury outright, you see a lot of people who have settlements from personal injury cases. So tell me a bit about your firm and the connection between your niche of elder care and tax issues and special needs planning and how that ties into settlement planning.
Sure. It's kind of interesting. You start practicing in one area and then your passion and certain events just take you to where you're supposed to be. I really feel that. And even though I started out in the mid 90s doing elder law and exclusively helping elderly people not lose their life savings to nursing homes, that morphed into settlement planning about 15 years ago when a guy I went to law school, who's the managing partner of one of the largest PI firms here in Western Pennsylvania, said, "Hey, you know all about this benefit stuff and Social Security and Medicare and Medicaid. Why aren't you helping, disabled people getting settlements?" And I thought, that's a great niche to be in. And as I started investigating what people were doing in that area, I found out that they weren't doing a whole lot. When I stumbled into settlement planning over a decade ago, I found that the majority of people were just not getting really good, comprehensive advice, both before and after they settled their case. They were either getting a structured settlement and heading on their way, or if they were disabled or had a label of disability, they automatically got shoved into a special needs trust and once again just kind of went on their way. And so we took it to, I think, a much higher level of representation to work with plaintiff attorneys. And as you said, Chris, I wouldn't know how to bring a red car, blue car case if my life depended on it. So we don't do that kind of work.
That's amazing. And you hit on some of the key questions I was going to ask is structured settlements. It seems like, the word structured, it means like, I think of like assembly line, like solving for the average. And so what is it that you do that's different? And what are some of the missed opportunities for those individuals that get those structured settlements?
Sure. And that structured settlement has its place. And that's just one component. Let me roll it back to the traditional situation that most plaintiff attorneys find themselves in. They do a great job working really hard to, verify and prove liability and then prove damages and maximize the value of their case. They're extremely busy doing that and they do a great job. And then normally what happens, at least with the attorneys I don't work with, is they settle a case at mediation and then they say, we better call someone, right? We better call someone to clean up the mess because we're going to get paid, our costs are going to get reimbursed, but we got to get someone to take care of this person for the rest of their lifetime, or at least, fix things. And that's where a lot of times, this last minute structured settlement offer comes in at the mediation table typically by defense, the defense carrier's structured settlement person. And that's not to say all structures are bad, but there's a time and a place for everything. As I said before, some people need a special needs trust. Some people don't. There's a lot of cases I do, 7, 8-figure cases where we don't use a special needs trust and the person may have a severe disability. So it's about custom building every case, especially on the larger cases, to fit the needs of the person. And I've always found it difficult to understand, especially on the bigger cases, how a person could assess someone's needs in 8 hours at a mediation and say, this is the investment you should have for the rest of your life. And that's the problem I have with some of those structures. But there's cases where we think structures are really good for people, but it's typically the smaller cases where they don't need a trust and it's more to fix a person from themselves. But to say also in that process is what makes us different is that we start working with the families long before trial and long before mediation. So some of the families I work with for 2 to 4 to 5 years without getting paid, by the way, with those families. And that's the difference is that, a person with a disability after their date of loss needs help, right? They probably have had a traumatic medical event and they've had a lot of medical procedures. They've got insurance questions. They've got care plan questions. Where am I going to live? Who's going to pay for this until I reach a settlement 2, 3, 4 years down the road? And so we brought social workers into our law firm many years ago, and we have social workers on staff, and that's our first point of contact. So the plaintiff lawyers we work with, they know we're going to send out our social workers, and they're going to start assessing that person's medical needs right away.
So, and that's incredible. And I love the proactive, the early estate planning. That's incredible because a lot of this takes a ton of time, like you said. So is it? Forgive me, I'm not an attorney asking this. Is it where? So you mentioned the 3 to 5 years. Are you paid? Are you compensated in the same manner? Is it like a contingency type compensation?
Yeah, I mean, we realize just like the plaintiff attorneys, most of these people don't have any money to pay attorneys up front, right? So we want to make it as easy for them as possible. So we act as that back office, so to speak, to the plaintiff attorney. We act as that additional helping hand with social work, estate planning, tax planning, and also helping the plaintiff attorneys to not make mistakes they may not even be aware of. And we do all that on a contingent fee. And so, for example, all the guidance, all the social work we're doing, if we're setting up some preliminary estate planning documents, if we're going out and the case doesn't settle, we just write all that off. Um, you know, I think most of the attorneys, well, all the attorneys we work with are pretty good, right? They're pretty good at judging value in cases. So it's rare that happens. So it's not like we're taking the biggest risk, to be quite honest with you. And the folks doing those liability cases are the ones putting all the money in and taking all the risk. But, we kind of tag along, and when the case settles, we get paid.
Love that. I love that. Let's talk about from the consumer side, and I want to ask you about a couple case studies, just some maybe stories that come to mind that you could share. But before we get into that, let's talk about just like the tax implications outside of like what are some of the tax implications in these settlements and the planning that goes into it. You mentioned some words like the special needs trust and these different types of setups. Could maybe you expound on just the tax side of things?
Oh, absolutely. On the bigger cases, I can give you a few examples where both the plaintiffs and the plaintiffs' lawyers are just throwing money down the drain. Okay, and I can give you, two quick examples. One, on any significant wrongful death case, one of the biggest mistakes I see is, whether that case is going to produce money or not, they should be filing an IRS Form 706 to elect portability. And that's a whole bunch of technical stuff. But what that means basically is when a person dies, they each have a lifetime exemption. And right now it's a little over $13 million of transferability. So when you go to the end of this case, 5, 10 years down the road, and this plaintiff is sitting on a 20 or $30 million recovery, they've got a serious federal state tax problem. And so we do a lot of federal state tax planning, and many of those things have time constraints. For example, you need to file for portability typically within 5 years of the death of the person to maintain it. And that's millions of dollars of credit. And so, those are just things that we talk to plaintiff attorneys around the country. And when I start telling them about federal estate tax planning, they say most of the time, we don't do that. No one ever talks to us about this. So that's one area on the wrongful death side. Then on the other side, we have people that have significant settlements that are in the high 7-figure, low 8-figure range. Typically, we're going to start talking to them about how do we hedge against federal estate tax for their family down the road? Because, the federal estate tax is 40%, right? So, you get someone a great recovery and they're sitting on $25 million and they only have a $13 million exemption that if their trustee and their financial advisor are doing a good job is going to keep growing, right? Every dollar right now over $13 million gets taxed at 40% when they try to pass it on to their kids. All right.
Unreal.
Here's the worst news. On January 1st, 2026, the 13 million goes down to 6 million. So that's another loss of $2.8 million out of pocket in taxes. So it's crazy. That's one big thing we do is the federal estate tax planning, both pre and post settlement. The second thing is on the punitive damages cases, it amazes me that people give this money out to the plaintiffs on the punitive damages cases without reducing the income tax on these punitive damages cases. There are proven methods that the IRS will accept to allow you to basically eliminate the tax on the punitive damages portion that goes to the attorney's fees. And I'm working on one right now where, unfortunately, they gave some of the money already out to one of the plaintiffs, but at least we're going to be able to eliminate the tax on the other one. And so, these are big numbers. These aren't, small little $10,000 tax bills. These are multi-million-dollar tax bills we're talking about. So anything we can do to add value, for the plaintiff's family, we want to let the plaintiff attorney know that as soon as possible.